Hello and welcome to this very special edition with SCC Online. I'm Anusha Soni. Today we present to you a very special conversation which is about the landscape of privacy in India. India, ever-evolving economy, one of the fastest economy growing in the world, has had its tumultuous relationship when it comes to privacy laws. It was back in 2017 that privacy was declared to be a fundamental right, but only very recently that we got a law in place, and just about a year ago, the rules were notified. Has India really done justice to the privacy of 100 crore plus people? And how are the rights of intermediaries, the laws around artificial intelligence really evolving in India? With me today, I have two formidable gentlemen, Mr. Sajan Poovayya, Senior Advocate at the Supreme Court of India, Mr. Arun S. Prabhu, he's a partner co-head digital at CAM. Thank you, gentlemen, for joining us on this very special conversation. Mr. Poovayya, first to you. From Puttaswamy to now, I remember you laid down your arguments before the Supreme Court of India when Puttaswamy was being debated before 11 judges. What is the kind of journey that India has really taken? Have we really made progress?
Anusha, interesting you're asking me whether we have made progress. If you look at it in general terms, I think yes, we have made progress. But if you ask me as a free speech lawyer, as a privacy proponent, have we made enough progress yet? My answer would be no. Just look at timelines. It was a 2012 litigation that ultimately landed up giving us Puttaswamy judgment in 2017. So it was a 5-year litigation from a division bench up to the largest bench in court. And then it has taken 6 years from 2017 to 2023 when the legislation finally was enacted. And then, of course, rules thereafter. But at the cusp of possibly the middle of 2026, if you ask me, do we, as of now, have a robust regime regarding data protection in this country? My answer would be, I don't think we have a robust regime. But do we have a regime? Answer is yes. Is it better than nothing? Answer is yes. Are we in the right direction? Answer is yes. But have we made progress? I think it's a very subjective assessment. I would therefore answer it as I did on saying we've not made enough progress yet.
Arun, would you agree with that assessment? When you're advising clients, and these are big companies who want to come and set shop in India, do more business, interact with Indian audiences, have access to their data in different ways, are they confused about what they need to comply with?
So I'm going to answer your two questions in separate parts. I feel that the direction of travel, I'm actually aligned with Sajan that we may not have made enough progress, but the direction of travel to my mind is far more apparent in my neck of the woods. When entities are designing systems in a manner that is intended to last for 5, 10, 15 years, be they notices, be they infrastructure designed to hold AI models, hyperscale data centers, basically large bets in India's digital economy. They're doing so on the back of the knowledge that they will have to process data in India in a far more sophisticated and legally compliant manner. People are spending large amounts of money, time, and effort in designing systems to comply with this new law. And come the 12th of May, 2027, there will be a new dawn from a privacy perspective. That timeline is validly set. Contrast that with Europe, where, for instance, the conversation around privacy, originated in the actions of the Nuremberg Tribunal, had the Data Protection Directive in 1991. After several years of, the Article 29 Working Party and so on, it took decades to form. And even then, when Europe went live in 2018, 2019, 73% of Europe was non-compliant, on the day the GDPR went live. So I actually think that we're in a good place, and I really look forward to the 12th of May, 2027. But in terms of the direction of travel, I do think we've done well as an economy. And I do think we must give ourselves the benefit of the fact that it's an incredibly diverse space. You're mandated to put out 22 languages under law, but quite apart from that, there are literal hundreds of others which are spoken. There are varying degrees of literacy. There are varying degrees of access to the internet. So given all of that, I actually think we're in a good place.
Mr. Poovayya, you have been a free speech lawyer, one of the top tech voices in the country. And I ask this question on behalf of citizens who think about sharing their data on internet. And yes, there is a concept of consent, and we all click on that button which says, I accept it. But is there really a free consent and informed consent that users are giving when they're interacting with social media websites, with intermediaries, or in the age of artificial intelligence, say using any latest chat GPT or any technology?
No, that's a very deep question. I think that really has its manifestations not just in the law, but in terms of how society behaves generally. This question could have been asked in any part of the world, let alone India as a robust digital economy. It could be asked in the US, it could be asked in any country in Europe, and you could ask the same question in Africa, where possibly the digital imprints and digital literacy are lower than possibly this part of the world. Whether the consent indeed from the citizenry in this country is informed, do they really know what they are getting into, are questions which have a larger penetration into the way our demography behaves, our demography treats its data, to what extent we value our personal data. Now, those are very difficult questions. It's difficult for the lawmaker, it's difficult for the law implementer. I think we should look at it in measured steps. If you look at the law as it stands, are we at least progressing in the right direction? Answer is yes. We are certainly better off today in terms of having this legislation than we were 5 years ago. Now, does the legislation modulate itself in a manner that it requires informed consent? Does it modulate itself in a manner that it requires purpose limitation to be brought into the entire ecosystem? Answer is yes. So therefore, has the law done well, at least in taking those baby steps in the right direction? Yes. Now, will that law be implemented effectively to ensure that purpose limitation really becomes something that we have all conceived of, and it has its checks and balances in the way data will be processed? We don't know. That's only time can tell. Also, yes, taking from what Arun said, please look at the heterogeneous nature of data that is available in this country, heterogeneous nature of the demography in this country, and please see the correlation between digital format data to analog data. And when I say analog data, I mean paper and every other form. A whole host of our data in analog format is available everywhere with no checks and balances. Your forms that you submit to a government office, the forms that you give for general regulatory consents and licenses that you need, whether it's your driving license, whether it is even a passport application, do you know where that physical application form ultimately lands up? It lands up in a godown which is not even locked, and then it lands up in some other trunk which is open for people to see your medical data from government hospitals. So therefore, in the analog format, if your data is all over the place, consent possibly is not even sought, why do you then unnecessarily in this transition phase pitch digital data in such a high format to say, oh my God, your consent forms are not correct, you're not seeking consent?
So to be the devil's advocate here, because digital does pose a risk that you could be profiled in a certain way, it also makes the transmission and sharing of data much more easier for good or for bad purposes.
Yes. Therefore, the question then should be on whether processing is regulated, not so much on whether consent of the individual is actually taken. And second, although I'm a strong by heart a free speech proponent and a privacy proponent, I think we have actually flogged this animal called surveillance a little too hard. I do not, if the volume of data that's available with all state missionaries in this country is so huge, that if surveillance indeed was such a large problem, it would have actually shown itself or manifested itself. Now, surveillance, is it an issue? Of course it is. Is it an important issue that we should deal with? Yes. But I don't think we should really be scared of surveillance or make surveillance the devil to demonstrate whether our laws are correct or not. I think the answer would be that we are now taking baby steps. Implementation of this legislation is more important or as important as the drafting of this legislation. Now, as Arun rightly said, please look at Europe. If Europe has found it difficult in terms of its implementation and it still has problems, if not teething problems, India is bound to have those problems over the next few years. But are we marching in the right direction? Yes. Do we need to do more? Yes. Do we need to actually train people who will implement this legislation? Answer is yes. Do we have that cohort of people who understand technology, who understand privacy, and who will actually have a light touch in terms of this regulation? Answer is no. Therefore, we need to actually train our people to do so, and that I think takes time.
So, Mr. Poovayya touched upon state surveillance, but one of the other ways consent interacts with individuals is the large corporations. And these have been the two pillars that one has been talking about, the state surveillance and how large corporates are really processing your data, not actually access to your data. Is that a concern that resonates in the minds of the companies or big tech companies? Because I'm reminded of a Supreme Court litigation where the top tech companies operating in India were summoned by the court because there were certain guidelines, intermediary guidelines that they were not following. They had to come up before the Supreme Court and explain their position. So there have been instances where the implementation or the compliance part of it has been difficult.
So yes, I mean, it's a fair call out, right? To use a hackneyed phrase, big tech is often the counterpart of Big Brother when it comes to privacy debates. Now, I think we must know that big tech, unlike big government, is balanced by two forces. The first is commercial experience, admittedly, but there's also the factor of user trust. User trust, which especially for large platforms, global platforms, is often transparently writ on the basis of their data processing practices, and is a priority or a imperative that they spend a lot of time A, creating, and B, preserving. They also work in a multi-jurisdictional environment. Unlike a government which can say, for instance, that all data which I put in public domain is forever excluded from the ambit of privacy in perpetuity, big tech cannot say that, right? Even public data, they are subject to restrictions on processing in other jurisdictions, and therefore they are often subject to that wonderful mathematical rule of the lowest common denominator. Now, if you take all of this together, what it means is that big tech has to process data in a way that is coherent, not only with the global grid norm, right, on the processing of personal data, but also in a manner that is ultimately palatable to their key audience. I don't think you should look at big tech as the yes, and obviously, like all important debates, there is pull and push, there is friction, there is debates, there is disputes, there is courts coming down on people, and so on and so forth. But ultimately, the end goal of large big tech organizations, especially the large platforms, is to provide a digital good or a digital service which is accessible by people. And at some point, there is recognition that if you go too far in the direction of profiling, targeting, etc., that becomes ultimately unattractive.
Let me take this question with you. Mr. Poovayya mentioned about European Union. We recognize privacy as a fundamental right, but it's not somewhere written in Part 3 of the Indian Constitution. It's all pervasive in Part 3 of the Indian Constitution. It's part of 21, it's part of 14, it's part of the Golden Triangle. Talking about European Union, for example, it recognizes privacy as part of dignity, autonomy. There is a strong rooting of individual rights when it comes to privacy. Do you believe there is a space for stronger mechanism here in India compared to other jurisdictions? I'm just using one example, but thinking aloud with you.
See, I don't think we should make the mistake of looking at India as a version of the GDPR. There is a historical common origin. Justice Sri Krishna's draft derived in large parts from the GDPR. But when the version was replaced, I think very resolutely India looked away from that document. We have a 14-page piece of legislation. There are recitals in the GDPR to individual sections of the GDPR which are longer than our entire statute. What we have tried to do is form a commercially expedient and a practically expedient solution which protects the rights of citizens while enabling data to be used and, to be fair, monetized to some degree at least by one of the world's fastest growing digital economies. This is not a zero-sum game. It's a bit of a balance between, as Europe found out with AI, over-regulating a space, creating a sort of license raj, effectively constraining both capital and innovation by over-regulating it, allowing both of them to flow to jurisdictions which are less careful, and having a practical functional regime in which the rights of individuals are preserved. So to answer your question, I don't think we look at privacy the same way as Europe. I don't think the regime that will flow out of the Digital Personal Data Protection Act and the Data Protection Board will resemble what happens with information commissioners in Europe. But at the same time, I don't think that's a bad thing.
Okay. Mr. Poovayya, your thoughts on it?
Well, I fully agree. I think just look at the variety in India. I think we have the variety for 3 Europes in India. And of course, don't even look at the population of this country and the digital divide in this country. If you look at the penetration of smartphones in this country, we are possibly more than Europe. If you look at the penetration of broadband in this country, we are as much as Europe. If you look at the amount of people who actually use digital modes for commerce, not just e-commerce, or even UPI has revolutionized what we do. Now, is our data therefore digitally processed, available every moment? Billions and trillions of rupees worth of transactions happening every month. Therefore, if you look at the robustness of our digital transactions and the digital economy, we are, I think, far more complex than any other jurisdiction that you can get. And therefore, I fully agree that I don't think we are going to do well by simply learnings of the GDPR are good indicators for us to learn from, in a perspective of what we should walk towards and what we should stay away, because the best experience is a third person's experience that you learn from and not your own. And therefore, to that extent, I think we are fine. But having, if not a fully sui generis method, at least having a methodology in the law in terms of regulations which apply to our cohort is important. And I think India is doing that in the right direction. The problem really is from a perspective of, does the regulator understand this animal before the regulator can regulate? Now, that question has always troubled India. Of course, with due respects to whoever is doing whatever, I don't think, not just in this field, in most fields, I don't think regulators really understand the whole ecosystem fully before they start regulating. And consequently, what happens is that it does not become light touch. You made a very, very good point, and that's true. Unless you have this light touch approach, unless there is a trust that you have in the system to saying that the system is not all pervasive in terms of violating everybody's privacy. The system has its own checks and balances. A large corporation, simply because it's large, does not mean it's bad. The large corporation possibly, as you rightly said, has a lowest common denominator that it must deal with, and the lowest common denominator is possibly higher than what individual thresholds that India is setting. From that perspective, an implicit trust is necessary on how the digital ecosystem operates, number one. Number two, I think regulators must learn to actually intervene only when there is a need, which means that I will trust you, it will be light touch, I will let you move forward, and only when I believe that there is an intrusive or incisive action necessary that I will get in. You got the example of saying Supreme Court had held up or summoned large intermediaries, they were to answer questions. A lot of it, in my view, and in fact I was counsel in some of them, a lot of it, in my view, was unnecessary. That is because the regulators looked at everything that is happening on the intermediary ecosystem with an element of doubt, and that came up before court. Fortunately for us, our judiciary is phenomenal in terms of achieving this balance. The Supreme Court considered the whole host of it and realized that all is not as bad as it is made to be, and therefore, with a bunch of directions, closed those proceedings. And that led to innovation. And the last word, in fact, on that matter is, please remember that law is not the beginning and end of the digital ecosystem. Innovation is. If you actually bring in a set of regulations which kills innovation, you can't really then get India to march towards being a superpower at some point in time. I've always asked this question. Why was Facebook not invented or incubated in India? Why was Twitter not incubated in India? Why are not some of the largest intermediaries not incubated in India? It's Indian mind which actually creates these inventions, but they are not incubated in this country. Why? Because our regulatory framework don't permit that incubation. And therefore, they get incubated elsewhere. As you rightly said, it will find a method to fly away, to actually become a behemoth and then come back. So I think therefore, India should learn from a perspective of saying that whilst privacy is important, whilst regulation of data is important, we have to make sure that large corporations do not really misuse data. Purpose limitation is necessary. Limited processing is necessary. But you can't start this process with an element of doubt. You need to trust the digital ecosystem. You need to trust the large corporations, indicating that they are not here unnecessarily to intrude into privacy. They are here to actually innovate, build ecosystems. If you believe that there is intrusion necessary, then intrude at that point in time. Light touch, and light touch, not heavy-handed.
I'm glad you brought up the issue of intermediaries. And as you pointed out, you've been a lawyer for some of the top companies that had to be represented before the Supreme Court. But asking you this question as a free speech and as a constitutional lawyer, when it comes to compliance of intermediaries in India, is there a rather negative approach that has been taken so far, to put it very candidly, to view them with more skepticism than they actually deserved?
That question should be looked at from two different angles. If you look at general privacy issues, etc., I think intermediaries have really acted quickly in terms of taking down content. But if you look at political speech, if you look at free speech in terms of the level of discourse, or the freedom in terms of the level of discourse on criticism. Each country has its own threshold. Now, burning the flag in the US is really, not violation of any law. You burn the flag in this country, you know what's going to happen. We're not just violating the law, you will actually have a backlash in terms of to the society itself. Therefore, if you look at community standards in this country and benchmark those community standards to whether intermediaries are acting as quickly or not as quickly, you may find two versions of whether they are or they are not acting. But if you look at bottom common denominator of takedown processes, whether it is the digital millennium communication, the US takedown policies, whether it's the UK takedown policies, and from that common denominator, look at whether the intermediaries are acting with precision in this country, acting with haste in this country, or acting in accordance with what they should in this country. My answer is yes, they are. It's the same standard that they apply in every jurisdiction. It's not that they're treating India any differently. The difference arises, or the difference in approach arises, because a takedown notice comes in a particular form that the intermediary does or does not understand, not because the notice is bad or the noticee is bad. It is simply because of the demography and the heterogeneous nature of this country. I'll take an illustration. A takedown notice regarding a particular video on Ganapati Bappa Moria procession being, or some overlapping conversations on this procession, a takedown notice being issued, somebody who's analyzing it in another part of the world does not understand it at all from the perspective of which law are you violating. So it takes time to understand it. In India, you do, but the person who's actually taking a decision to pull it down may be sitting in another jurisdiction. Therefore, it's important then for every country, and more so for India, to arrive at a common standard operating processes in terms of what the notice must contain, what should it explain, consequently that intermediaries can understand it and take it down quickly.
So you think this is a problem of communication?
It's a problem of lack of standardization in the process for takedown notices. Takedown notices come in different forms and sizes. I was told when I was in high school that Cupid can come in different forms and sizes. You don't know how Cupid looks. And that's the problem with our takedown note. You don't know whether it is, sometimes you don't even know whether it's a takedown notice or not. And that leads to delay. And you know what happens in technology when there is delay. There is geometric progression in terms of transmission of this data. Then it's a mountain out of a molehill thereafter. The problem becomes acute. And at that point of time, allegations are made saying, which or the other, one or the other intermediary is not acting. I believe all of this can be taken care of, provided you believe you build SOPs, have standard operating procedures, have standardization in terms of what these notices must contain. And of late, we also had a scenario of saying that who can issue these notices? It can't be that all in-centric can issue those notices. Who can issue the notices? What should the notice contain? What are the thresholds that the notice can ask you? And how much time would you give the intermediaries to pull down? If there is reasonableness in panning all of these four conditions, I don't think any intermediary would want not to comply with it, because it doesn't augur well even for their own businesses not to comply with it.
Arun, would you concur with that? Is it a problem of processes and not having the SOPs in place?
Yes, it's a problem of coherence. It's a problem of coherence, it's a problem of consistency, and it's a problem of a legal regime that thrives in uncertainty. The intermediary bargain, as I call it today in India, is put out a set of rules as we mandate it, perform certain actions, which is notice and takedown, based on our instructions. And third, comply with court orders, and we will keep you safe from the underlying content. That's the original sort of safe harbor bargain. The issue is, and I think Sajan called this out very, very clearly, that different people speak in different tongues when it comes to these exact same requirements. Where any set of large, sophisticated intermediaries has consistent rules of the road, they actually tilt towards coherence, because things don't get taken down by some human being pulling up, like something out of a computer. They get taken down through automated means. And what do automated means work well with? They work well with coherent rules. If someone were to set out a rule saying, look, this is the direction, it will come from this person, this is the time you have, sometimes it doesn't even identify the content. Half of my clients come to me saying, hey, we've got this notice, it's referring to this video. I know one version of this video is here, but I don't know where else it is, right? I have IP addresses which aren't even relevant. They're not static IP addresses. They don't have timestamps. I don't even know what server to take down, what access to give you. There are provisions of the the Criminal Procedure Code as it was then, which allow even sub-inspectors or investigating officers at the station level to send you a direction saying, give me access to this, and you have to provide access to it. So the lack of coherence, the lack of seriousness or substance in terms of the application of mind in terms of how these orders are issued, the absence of a clear mechanism to go back and say, hey, is this a valid order? Is this issued by the person it purports to be? Because guess what? Fraudsters love using this to prompt takedowns, to prompt aggressive positions, to prompt disclosure of information which shouldn't be disclosed. So to my mind, I fully agree with Sajan. The issue here is not compliance. The issue here is coherence. And if I may be a little more provocative, the lack of coherence, one comes from the nature of us as a creature. The nature of us as a creature, we're very diverse, we're very disparate, but it also comes a little bit from design. The fact that we're relying on a 2000 piece of legislation and intermediary rules which date back, this intermediary bargain of this so-called safe harbor which you are given and so on and so forth, to enforce a set of rules which is now literally dozens of pages long, is fundamentally incompatible. I do feel that purpose-built specific regulation in this space, legislation in this space, is long overdue.
I think you've made a very valid point, sir. Is there a need for targeted legislation?
Absolutely, yes. Safe harbor was all fine, possibly not even in 2000, maybe in the mid 90s and leading into possibly early 2000s. Let me put it differently. No, safe harbor just now, I don't think works, not because there is something inherently wrong with the principle, not that there is anything inherently wrong with the harbor, that you can actually anchor your ship there and you'll be safe. The problem today is that ships have become larger and harbors have become smaller. So those ships don't enter this harbor. Now, if you make your harbor so small that you will only have maybe small trawlers and fishing boats, and the larger ships will have to fend for themselves at sea, then it makes no sense to have a regulation of that nature. You have large corporations, name 4 or 5 of those corporations, their market capital is bigger than possibly the GDP of India by multiple times. Now you are looking at those, you're looking at the quantum of data that they process worldwide, quantum of data that they process here, the nature of that processing, multiple levels of processing, and throw in artificial intelligence there, it even complicates that further. Yeah. And then you have a set of, in my view, very archaic set of rules on saying, oh, I will give you safe harbor provided you don't do ABC, you're not the originator, you are not actually the recipient, you are not modifying the content. It's all well for a law student to read, but simply that mechanism, I think, has stopped working. Therefore, targeted legislation which will not fall far behind technology is very important to deal with the situations.
To take that conversation forward, our law on data protection is not very old. I know we're talking about the Information Technology Act of 2000, and there have been demands that there should be changes or amendments that need to be brought into it. But if we were to use this platform as for making some constructive suggestions, what are the provisions perhaps that have become redundant, or broad suggestions that you think that the stakeholders or our regulators should think about?
On data protection?
On data protection, Information Technology Act.
So I'll answer the more difficult question first, which is data protection. I actually feel that, by having a brief principle-based law, the government has got that balance somewhat right. There are parts of it I disagree with vociferously, as you can hear, but broadly, we have a general purpose law which will, to my mind, knock on wood, stand the test of time, even as technology and privacy evolve over time. Where I think real intervention is needed to make sure that we don't sort of lose out on the plot after having put several decades into building it is the point Sajan made, which is enforcement. We have a very unique regulatory architecture under the Data Protection Act, and it's one of those vehement disagreements. The Data Protection Board is not a full regulator. It does not have the ability to make rules. The fundamental regulatory bargain in any space is do these 4 or 5 things nicely, and I won't penalize you. Follow these rules of the road, and you won't get fined. In this case, the rules of the roads have to come from the mighty. They have to come by way of delegated legislation under the law, and we know the time, effort, and process that it takes to actually be able to do this. Contrast that with GDPR, where, for instance, the Article 29 Working Party put out 1,400 pages of guidance before anything was done. It would politely write to people saying, "Dear Dash, please explain." And one of my clients got it, so I know this exists. Please explain how you're doing this. Even before the law came into force, 2 years before the law came into force. Please explain how you're doing this. Tell us how this is coherent with the forthcoming legislation. So people have the way to address their business models even before. And when the law came into force, they didn't start handing out notices. Their printers didn't start smoking. They politely sent several notices to people saying, hey, can you do this differently? We believe this activity is problematic. They have on record investigated large-scale breaches and said, your obligations and your compliance is broadly in line with your statutory obligations. We will not fine you, even in the context of large breaches. A balanced set of regulations, which is mindful of how the sector operates, how technology actually works, the fact that breaches are not completely unilaterally under the control of any one individual or entity, and with a view to creating a workable framework, a workable digital ecosystem for India, is to my mind the single most important regulatory intervention that can happen as far as the data protection law is concerned. You don't need to change the law. You do need to change, or at least hopefully change, how the regulator operates.
So, Mr. Poovayya, how can we make our harbors bigger? Any free advice you'd like to give to the regulators?
No, I think India has done well in multiple other modes of regulation. As we speak, I can think of, post the World Bank model of having independent regulators. India walked into that path. Just look at from 2000 downwards, or possibly 95 to now. Some of the independent regulators in this country have done a phenomenal job. Take electricity, for example, power. The regulators at the state level, which is the State Electricity Regulatory Commissions, at the central level, the CERC, the Central Electricity Authority. And as Arun rightly made, although there's one legislation, which is the Electricity Act, the power to make regulations is given to the regulator. It is the state regulator which makes the regulations. It's the central regulator which makes regulations. Every state and the CERC have made multitude of regulations on every aspect of electricity. So a power generator knows what to do, a power consumer knows what to do, a DISCOM knows what to do, a transmitter of power knows to do. So between the transmission company, distribution company and the generator, there is regulations that are made and regulations that are amended from time to time as technology in that field develops. India has become a world leader almost in renewable energy today, courtesy those regulations. Now, if you can bring in that amount of clarity, do we have problems in electricity regulation? Answer is yes. Do we have a whole host of disputes in the appellate tribunal and the Supreme Court? Answer is yes. But that's besides the question. Do we have at least giant steps taken in the way the regulators must act? Answer is yes. And we have made that. We have done so in airports. Please look at our private airports. Some of the best private airports in the world are in this country. And please see how they are regulated. Now, you have an independent airport regulator, you have an independent power regulator. Please look at how the Competition Commission is looking at it. People may have trouble with the decisions, they may appeal the decisions, but there is some form in terms of regulatory approach to a problem. And I think the point that Arun made is crucial. You can't have a board and indicate that you will be the regulator, but you will not have the power to make regulations. The state will make those regulations and you will implement it. The answer is, and if you ask me, what's the advice? I think bringing it to its elements, I think we are looking at this as a policing activity. No, you don't look at data protection as a policing activity. I will find who's the culprit, who's breaching it, and I will find him, I will punish him. Policing activity has never worked. What we need is a crowd of innovation. So what we need is crowd control, regulation. We don't need lathi charge by the police to disperse that crowd and therefore chase innovation away. What we are looking at it is as if it's a lathi charge. Oh, you commit a mistake, I will now take you.
Then how should we view it if it's not a lathi charge?
Therefore, the only way you can view it as crowd control and getting discipline into that crowd, so that you need the crowd, you need network effects, you need innovation, but it must be regulated, is to bring regulatory certainty. And regulatory certainty does not come with one legislation, it does not come with one rule. Regulatory certainty comes, and he made that point, it comes from the perspective of constant innovation in the way you will regulate, which means multitude of regulations coming from time to time. They having the flexibility to amend it within a limited time frame, amend it to suit a particular purpose. That can be done by the regulator, not only by parliament and by the executive in terms of making rules. So I think that architecture of regulation must change. If you don't trust, okay, you may not trust the data processor, fair enough, it may take time for you to trust it. At least trust your regulator. Please give your regulator more power so that the regulator then decides what sort of regulations must come in. Those regulations ultimately then will give clarity to the operator. The minute the operator has clarity, the operator will make sure that the checks and balances that are available are woven into the operator's business. And automatically you will have less intrusion and more compliance.
So no lathi charge approach.
Absolutely
I think
not.
I'm taking that line.
You can't really have a lathi charge approach. Yes, the first victim of lathi charge will be that innovation will run away.
Yeah.
That's all it is.
That's all it is. I think artificial intelligence deserves whole 1 hour separately, but I do want to touch upon it. We had a wonderful 2026 summit here in India, a lot of interest shown from across the world. But still, there is no whisper of any kind of regulation/law that regulates artificial intelligence in India. Isn't that a big void? Arun, first to you.
So I'm going to be provocative again.
Please do.
We have, and I quote Justice Sri Krishna, the Justice Sri Krishna committee on this, we have ample law that regulates artificial intelligence in India.
For example?
So let's take, for example, lending, right? Lending, just normal lending. There is an entire framework put out by the Reserve Bank of India, ranging from the rules that apply to NBFCs, the rules that apply to credit approvals, the rules that apply to collection activity, the rules that apply to digital lending, etc., which parts very well to an AI-driven lending workstream. Similar rules put out by SEBI in relation to trading, in relation to market leading, in relation to price fixation and price control, in relation to fraud, which pass very well to AI-driven algorithmic trading. Yes, there's a little bit of additional regulation which is done for specific things. But as SEBI CSCRF has shown, you can look at this in a very clear horizontal manner. To me, AI is more about how you do things. AI is a horizontal layer. It's a means of enabling business. To look at it as a separate line of business which needs to be regulated in some unique way is, to my mind, a little bit myopic. We need to look at the entirety of the laws that we have to see whether they are AI resilient. Are they able to regulate the exact same activity which is done by AI in terms of frequency, in terms of scale, in terms of time to market, in terms of its disruptive activity potentially on the old way of doing things? To my mind, what is needed is customization. It is not the creation of standalone legislation. I will go back again to the point we made. EU's AI Act has been validly and publicly called out as a strong reason for why organizations choose not to innovate in specific geographies. Were India to go down that road, the consequences are not just losing out on additional capital. The consequences in India are at an almost population scale. If we do not find a way to use large health databases to predict disease, to provide for preventive medicine, provide for nutritional therapy, to provide for large-scale ordering of drugs and large-scale drug development to address issues, the impact will be millions of lives. The consequences of non-adoption of technology, and by balance, the advantages of adoption of technology in India are population scale. To my mind, we don't have the luxury of following a ultra-conservative approach.
No, I agree with you there when you say that AI in itself is not something, it is the way of doing things. It's the processes, automation and technology that you introduce in a certain procedure. But it also completely alters the way in which things are functioning and working. Mr. Poovayya, I'll take that point to you. So for example, let's talk about the field of medicine where AI is introduced. They have access to hundreds of people or lakhs of people who have gone through a certain disease. And it's predictive analysis that artificial intelligence is offering. And based on that, certain doctors perform certain actions. And they prove not to be very beneficial for the people on whom they were acted upon. The issue becomes of liability. Who is liable here? So AI does introduce an element where you do not know who to hold accountable. And to that extent, in my understanding, there is a need for some kind of regulation, especially in sectors like healthcare, in mental health care, where AI has made massive inroads.
Correct. And I think, no, both these points are right. And therefore, the perspective is not to look at AI as an animal, but really to look at AI as an enabler. AI is not an unruly animal. And the minute you look at it as an unruly animal, and Europe tried to look at it as an unruly animal, you will end up bringing one standard legislation for AI to comply with it. It's just not, you might draft the best legislation in the world. I can certainly tell you, ready to wager on it, that you cannot implement that legislation. It's impossible. In fact, that's something which you should not really walk that path. So the issue is not really so much in terms of indicating whether AI should be regulated on a standalone basis. AI or implementation of AI or integration of AI in multiple streams might require regulation in those streams. Therefore, strengthening regulatory approaches in each of those streams, also to accommodate AI-enabled activities, is the key.
So you're saying sector-specific.
For example, look at trading. Look, if you're looking at trading, it's for SEBI to make sure that its regulations coming forward are prudent enough to ensure that activities which are AI enabled are also regulated in a manner that it would otherwise regulate traditional activities. To what extent should those regulations change? How much should they accommodate? How much should AI enabling be allowed? Are all questions to that regulator. So it's not a standalone legislation from the parliament to saying I'm regulating AI. Now, therefore, on that regulation, I personally believe, as much as I am a free speech lawyer, I don't think you should come hard on AI being an enabler to those activities in terms of how you will regulate it. Leave it to those sector regulators to learn from these experiences and strengthen those regulations. The question of tightening the screws comes up not in regulating AI, but in terms of pinning accountability for AI-driven activities which leads to victims and consequently victim compensation. On that sphere, you can be very, very rigid. If you are indicating to a business that if your activities are AI enabled and these are possibly even at the cost of pushing towards strict liability on organizations, it may be in cases that you put strict liability, if not absolute liability. Those may be models that you look at for victim compensation in terms of AI liabilities. But that can't be mistaken to a scenario of regulating AI itself. Regulations must, again, I can emphasize more that regulation when it comes to AI, for example, in intermediary, that's a big mix. You have intermediary regulation, which itself is in a bit of a flux in this country. Now throw AI into intermediaries, and will intermediary who uses AI for choosing what data will be popping up, will it lose safe harbor or not, is a crucial question. Therefore, you can't bring it to a scenario where you look at AI as the bad one and try and bring stringent regulations for AI, which would mean to what? That AI-based innovations again vanish. Again, within AI, you have different modes. One is AI as an enabler in terms of traditional activities being made possibly more prudent. And the second one is Gen AI. When you're actually generating content from AI, that may require a separate set of treatment. Even there, you don't make all Gen AI, into absolute liability. Watermarking, for example, is one of the easiest method by which you can bifurcate content which is true, which is fake, or which is AI generated. Please bring watermarking today. Please indicate that content which is Gen AI content will be watermarked. Please see how society reacts to it. Please see how business reacts to it. Please see how the regulators will deal with it.
But sir, the point that you just mentioned about some flux about intermediary guidelines, some confusions around it, developments that are happening in that, plus the Data Protection Act and plus the artificial intelligence regulation, this is a void that exists. And the answer to that void cannot be no regulation or no answer from the regulators.
Who is the regulator is the question, not that no answer from the regulator.
Yes, I agree
Therefore,
with you.
you can't have a central regulator to indicate that I will regulate artificial intelligence. Let's come back to the example. See, these are all technology-driven problems. Today, we are in 2026. Go back to the 1800s, go back to early 1900s. Electricity was a problem. The law came in. Electricity was invented first and then came legislation to govern electricity. It took possibly 50 years for US and Europe to see how you will regulate electricity in terms of interstate transmission of electricity, inter-country transmission of electricity, where will liability be cast. But you did so. It will take time here. But I believe, unfortunately, the discourse in this country when it comes to AI is, AI is a disruptor. Because AI is a disruptor, you need to regulate it. You need to regulate and make sure that there is no disruption. Please understand, madam, the biggest innovations come from disruption. And disruptive technology led to possibly the most number of unicorns in this world. True. And therefore, I believe that a centralized regulatory framework for artificial intelligence is not the way to go for this country.
Arun, your thoughts on that? Centralized regulator, not the way to go?
Absolutely not. Yeah. Absolutely not. To me, sector-specific, nuanced enhancement of existing regulatory frameworks that market participants are familiar with to address AI activity gives them to use Sajan's phrase, gives them the crowd control. Right? They're used to walking to that temple every day. You're now putting guardrails on both sides of it so nobody gets crushed. To my mind, that's a far simpler, far more sustainable, and far more innovation-friendly approach And to reiterate my earlier point, innovation in India is not a good to have. Innovation in India is a demographic necessity.
Okay, my final question as we wrap up this conversation, there is an intrinsic relationship between data privacy, data sharing, and artificial intelligence. Take generative AI. The amount of information that we are putting on different platforms, and some of us do consciously, some of us do inadvertently. There is no legal answer to it that we have really come across so far. Do you expect one? And is that something that we should really think about? How do you see this intricate relationship between data privacy and also the growth and development of artificial intelligence in India?
So I think, like all great relationships, there is a beginning and there is an end. At the beginning of it is, of course, at the stage of development. Large language models feed on data. They feed on unique data sets. The more extensive the data set, the more capable and the more valuable the outcome of that training is. Now, obviously, as you've seen from the DPIIT committee and that approach, there is already a strong approach towards monetization and capturing value of some of that data, some of that innovation. But I will leave that debate aside for now, because to my mind, that's a financial debate. That's not a constitutional or a rights debate. But on the opposite side of it, which is when the rubber hits the road, where people put their own personal information on AI models, when people get insights which may affect their outcomes, affect the outcomes of people they care about from AI models, I think that is where fundamentally there is a little bit of a lacuna. Legally, of course, the approach to putting a piece of information into a search bar and putting the same thing onto a large language model or a Gen AI tool is indistinguishable today. I do feel there is a need for strengthening. I do feel at some level that the current approach, which is to look at it from an intermediary lens, for the reasons Sajan called out so clearly, may not be very sustainable in the medium to long term, because by definition, these companies do a lot more with data than conventional intermediaries. Right. So I do feel there is a need for upscaling. Do I have a plain cookie cutter answer? Do I believe for a minute that this is a question of just ascribing liability? I don't. There are more complex issues, for instance, like medical and legal privilege. A lot of people talk about suicidal tendencies on platforms of this nature. People put their, mental health issues, diagnosis, right? If I get a scan today, I don't wait for an MRI report. I put it on AI immediately, right? And it diagnoses. Sometimes it tells me I have 15 cancers, and sometimes it gives me a great analysis, right? Yeah. So fundamentally, I do feel, I don't have an answer for you on this one, but there is clearly a lacuna there.
Mr. Poovayya, how do you see this lacuna, and what kind of relationship it is?
I can only say that relationship is thriving, but it is intricate. And in an intricate relationship which actually builds value from a societal perspective, this is not just value, as you rightly said, from a financial perspective, from a constitutional perspective, legal perspective. I think this intricate relationship between data processing, intermediaries, artificial intelligence, Gen AI coming into the mix, throw into that mix commerce, and therefore digital commerce coming in, the cohort of multitude of the demography, the diversity in this country. It's a very, very intricate balance. Is it thriving? Answer is yes. Should you let it thrive? Yes. Will you therefore, when you learn a sport, would you hurt yourself a little? Answer is yes. But then if you hurt yourself and stop learning, you will never be that master sportsman. India should really target itself. I was so glad when India positioned itself in the summit to be one of the world leaders on artificial intelligence. That was possibly one of the sweetest moments for me as a technology lawyer. Now, having done that, you can't get your legal instruments to come and disrupt it or kill it. Your law should therefore enable it. Now, an enabling legislation can come only from learnings. Therefore, you need to give it some time so that the country learns, the regulators learn, the market participants learn, and that's when you arrive at a regulatory framework which will augur well both for the recipient and for possibly the person who is leading that information to the recipient. Therefore, today, do we have an answer saying we have a solution where one solution fits everything? Answer is no. If you have such a solution, I believe the remedy will be worse than the malady. And consequently, the only way I believe this regulation can occur is to coming back to that point, trust the market participant. Please have sector-specific regulations. If you believe that the market participant is not trustworthy, please deal with such market participants with an iron hand. But please don't tighten your regulation by looking at the lowest common denominator of a non-complying market participant saying, now I'm going to apply that yardstick to everybody. I'll leave with one scenario. We've done very well on our laws. Hindu undivided family and succession in the Hindu undivided family is one of the most complicated aspects in any part of the world. Our legislations have done very well when it comes to actually Hindu undivided family and how succession should take place. If complex aspects of that nature have had legal solutions over a period of time, there will be trial and error on it. This will also find, but you cannot find it overnight. And the governments of the day or the lawmakers of the day should not look at it as an opportunity to say, I will become the leader in terms of making this legislation in the world. If you do so, at least I have found as a technology lawyer, the first few market leaders on legislation have always failed. It's the later legislations which have actually brought in a sense of, for example, Europe with AI.
Or GDPR.
Or GDPR, yes. No, please look at AI in Europe. Why is it just shot itself in the foot? We shouldn't become that. We shouldn't be sleeping. We shouldn't be caught napping. But I think, therefore, an open-minded regulator who will learn from the ecosystem as much as a market participant learns is the key.
Thank you, gentlemen. Thank you for this exhilarating conversation.
Thank you very much.
And I hope to have more with you in the future as well.
Thank you.
Thank you so much for watching.
Thank you, Anusha. It was great speaking to you after very long.
Thank you, sir. Thank you, sir.
Thank you.